Thank you very much for having me here. Does everybody hear me? Okay. So, just a quick presentation of what general research is. I've done previously research on how both migrants and autochthons perceive citizenship. I've done research on the laws. And I've recently branched out in a third, let's say, field of research within citizenship studies, which is those who apply the laws. So we have a lot of work on what laws are. We have increasingly researches on the experiences of naturalizing. We don't have so much about the procedures themselves, and especially on the people who apply it. And the part of the research that I will be presenting today is based on a number of, let's say, theoretical assumptions. First of all, the idea of formal citizenship as property, as something you have, inherit, obtain, pay for, and use. And more specifically about the fact that formal citizenship has specific uses that are both linked to settlement and to mobility. I've used mostly data on migrants and autochthons in Italy to explore the uses of citizenship. I'm now doing the research in other parts of Europe, so Belgium and the UK, on how and what the implementation part can add to it. And I'm using street level bureaucracy, even if some of the bureaucracies I'm studying are not actually street level, so that they're not directly open to the public. But I'm using street level bureaucracy as an approach that explores how in practice bureaucracies work to meet requirements that come both from the law, from the public, and from the higher levels of the institution. And the final, let's say, theoretical frame I'm using is that of defense naturalization, which has been mostly developed for the US. Firstly, from the 1996 welfare reform, which basically excluded non-citizens from the little welfare that existed in the US, driving up immediately the number of naturalizations. This concept has been more recently expanded not only to specific initiatives that have been voted and already implemented, but also to a general political and legal situations in which the political system is signaling hostility to immigrations, and consequently numbers of naturalizations goes up, both to protect oneself from loss of rights and when sufficient mobilization exists in migrant groups in order to have a higher leverage in terms of voters who can contrast the potential loss of rights. As I said, I've done interviews with the bureaucracies of naturalization. In Belgium, this included the 6 magistrates that actually decide on naturalization applications, civil registrars, which have somehow, I will explain shortly, a filter role in the process, and 6 associations that help with nationality applications. In the UK, I actually conducted most of the research with a colleague, Emilian Fargues, who is currently doing a PhD at Sciences Po Paris. And I've interviewed some 14 officers of UK Advisors in Integration Liverpool, and some 6 officers of UK NAREC in Sultan. UK NAREC is the agency that certifies that your foreign diploma, for example, is valid. Foreign degree, not diploma, is valid, and that, for example, you don't have to go through the UK English language test in order to naturalize, but you can just use your existing degree to prove you already know English. And 7 nationality checking services, which are institutions that local authorities can activate to help with the procedure of naturalization. This actually didn't came as I probably did at the LibreOffice, but just to explain shortly, what is the main difference between the nationality law in the UK and Belgium? Nationality law in the UK is highly discretional, so for the letter of the law, there's almost limited discretion from the Home Secretary on each nationalized application. Very few of the criteria are formalized, and there's a limited judicial review. Whereas in Belgium, there's a highly codified, highly defined system legislation in which all the requirements that have to be met, and there are many in terms of economic, linguistic, and cultural integration, have to be obtained through specific documents you obtain from other institutions for other purposes. It apparently leaves almost no space to interpretation, and it has full judicial review. However, once one goes on the field, both cases are not so clear-cut as they are in the text of the law. First of all, while naturalization in the UK is theoretically highly discretionary, a guidance exists to limit significantly the discretion that exists in the law. If only the law existed, almost any kind of discretion and arbitrary decisions could be made by the Home Secretary. It's much less so because the guidance has a semi-legal value that is actually applied by UKYI and limits significantly the discretion that exists in the law. One important aspect is that the decisions are centralized in a single center in Liverpool, so a single team of 100 and some officers decide on all naturalization applications in the UK. Nationality checking services exist locally for local authorities who decided to activate them, but they are mostly help. They don't have a real filter role, and they also don't always have advice role. They can give some advice mainly by asking Liverpool about specific situation, but they do not have such an active role. And as I mentioned, there's a very limited access to judicial review, so if you are denied citizenship, you could firstly, let's say, appeal to UKYI itself, and your appeal could or could not be considered. And in limited cases, you could go to the court, but this is exceptional. Whereas in Belgium, as I mentioned, the law is highly codified. You have mandatory to pass through the register of your municipality, and this is a main issue because although the registers do not have clear powers to refuse to transmit the application to the magistrates, many do so, and if they do so, you cannot use the judicial review that exists if a magistrate denies you naturalization. If the municipality considers your application to be unlikely to succeed and stop it there, there's not much you can do except insist with them until they decide that you are deciding to take the thing in your hand and they send it over. The decisions are not taken in a single place but in 12 different local areas, which means that between local area with local area there are actually spaces for interpretation, despite the law doesn't leave so much space for this. There's actually interpretation going on, so you can have very different outcomes depending what is your municipality of residence. On the other hand, if you get to a magistrate and the magistrate denies you naturalization, you can always go to court and appeal against the decision. So this is the general situation which is necessary to explain what are the specific conditions of the two groups I will be presenting today, which are the EU citizens in the UK and British citizens, any particular British personnel of the EU and Belgium. So on one hand, for EU citizens in the UK, the main issue is that the relative protection EU citizens have had and still have until the end of Brexit negotiations becomes counterproductive when one tries to naturalize. Several aspects that help you in relation to other migrants to be on UK territory makes your application more complicated. First of all, freedom of movement means that you don't have stamps of enter and exit on your passport. Without stamps of enter exits on your passport, you have to prove otherwise that you are actually on British territory for the qualifying period. If you have to prove it otherwise, it means that you have to bring P60s, letters from your employer, bills, and so on, just to prove that you were on the territory in a given moment and that you have not exceeded the 90 and so days that you are allowed outside the British territory in the qualifying period. Whereas if you are not a EU national, you don't have free movement, but at least the only thing you have to bring to prove your presence on the territory is a passport with the stamps. There was a procedure recently to make permanent residence mandatory for EU nationals to apply, and the justification we received at UKYI for this procedure was that the nationality team of UKYI didn't feel competent in determining the exercise of treaty rights that are behind the naturalizations of EU citizens. They asked the EU team that exists within UKYI to do so. The problem was that at that point, according to them, the EU team was doing for free something they would usually take a fee to do, that is check that you have actually used your treaty rights that you are entitled as a EU citizen to be in the UK, which meant that the EU team left behind nationality applications to be processed because no fee was coming from them. In order to avoid these applications to be left behind, the decision was made, well, let's just make permanent residence mandatory for applications, so the European team gets its fee, it does the job they are able to do, and we just get a permanent residence. This, first of all, introduces all the problem of permanent residence in terms of how complicated the form is, in terms of the fact you have to prove several requirements in terms of exercise of treaty rights, which is not so much a problem of meeting integration requirements, it's a problem of proving you have continuously, without significant interruption, used your treaty rights in the territory, which means you have to bring a lot of documentation to prove that for the 5 years you have continuously actually been either a worker or a self-sufficient person or a student in the UK. But does at least this mean that naturalization is easier? Not necessarily. First of all, unless you are applying based on the marriage with a British citizen, you still have to prove your treaty rights and your permanence on the territory for the year that has to pass between when you obtain the permanent residence and when you can actually apply, which means that you still have to prove, at least for that period, that you are still exercising treaty rights and you still have the requirements that you have proved for the 5 previous years with the PR. You also have to prove you were on the territory on the first day of the 5-year period before applying, which means that you still have to prove otherwise from the permanent residence that you have exercised rights. And finally, interviewing different nationality checking services, I've met nationality checking services that just send the application with the permanent residence, and others that still collect the proof for the 5 years already covered by the permanent residence. They again check not that you have treaty rights, which is already proved by the permanent residence, but that you are actually in the territory in the 5 years you have spent before obtaining permanent residence. And we actually asked both a caseworker who processed these applications and someone from the policy team which decides what are the norms, and the caseworker actually said, well, if they do so, they'll probably be doing well because we have faith in the fact that the NCS are sending us necessary documents, and this might be the case for EU applicants that they still need to prove their presence on the territory. Whereas the policy team wasn't so clear that there was a requirement, they were more about permanent residence certifies the 5 year, but you still have another year to certify. Whereas for the British person of EU, the big issue was that on one hand, you are obviously to be a US citizen in order to work to the EU. This is a basic requirement for any position. This brought, as soon as Brexit talks were started, they started even before the referendum, but more so after the referendum, the British person of the EU, so mostly people living in Brussels and the municipalities around Brussels to go and try and get Belgian citizenship. If they become Belgian, they don't lose EU citizenship with Brexit, and they can manage to maintain their job. The problem is, as personnel of the EU, they are entitled to diplomatic documents which are give high protection and assure that full protection is given for the whole period. That are probably highest level that a foreigner can have in Belgium in terms of guarantees, in terms of permanence of the territory, access to rights, and so on, except obviously vote. But there's the small detail that diplomatic documents do not count toward the requirement of residence. You can have spent 20 years in Belgium with diplomatic documents, you will never have a single year of permanence on the territory because it doesn't count. This is mostly a practice in the international law to avoid the personnel of embassies to naturalize in the country in which they are deployed and create problems of conflict of allegiance between the country representing their country they're in. So what are currently the British personnel of the EU trying to do in order to circumvent the situation? They firstly have to convince the municipality to send their application. And for once, municipalities are entitled not to do so because law clearly states if you are on diplomatic documents, you don't have residence, so you never get a basic requirement for naturalizing. If they manage to convince the municipality to let them pass through, they have a magistrate that will almost automatically decide against the naturalization, which means going to court, and once they arrive to court, trying to establish a precedent by which somehow they could try and make the period on diplomatic documents recognized as residence in the country. Additional problem exists that the red area you see, which is the area covered by the Court of Brussels, is 2 to 3 years behind in processing the cases that arrive to the court. So there's no way Brussels will decide anything on this before Brexit talks are over. So their only hope at the moment is that some of the neighboring courts, in which some of the British personnel of the EU actually live, manage to get the case to the court and decide of it before Brexit talks are over, because once Brexit talks are over, automatically people lose EU citizenship, and with it the job. There's little point in becoming Belgian after that and trying to get the job back. So to conclude, first of all, these are two cases which are not only obviously an issue for who is in this specific situation. There are two cases in which people who are highly protected compared to other migrants have found themselves at a concrete risk of a concrete and drastic loss of rights. And not only, as I'm shown, there are not many political decisions taken. There's obviously making permanent residence is obviously a political decision. It obviously also has political viability in a context of conflict with Europe. But many other issues which were not taken, and there are no specific political decision taken, have just came up in the moment in which Brexit was started, and was to some degree not foreseen by the governments of either the UK or Belgium or the EU. So not only we are seeing that being highly protected can become counterproductive if this specific protection falls down and you realize that you have spent several years without specific requirements because you didn't have to have that requirement because you are relatively privileged. But also that only to a certain point this can be attributed to political procedures which we could analyze in the parliament in the declaration of the elected, or in the simple discretion applied by a single officer, but rather that the functioning itself of procedures and I finish it. The function itself of the procedures can bring situations in which a single change, although not a small one in the case of rectified, but in some cases even a small change, can have unintended consequences which might leave a smaller or larger group of people losing rights without necessarily any political will or any specific other legislation being passed in this sense. And I thank you for your attention.